Welcome to today's program titled Understanding the Corporate Transparency Act, What You Need to Know Before the December 31st Filing Deadline. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write the code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker, Jason. You may begin.
Thank you, Joanna. It's a pleasure to speak with you today. My name is Jason Polivoy. I'm a partner in Seyfarth's real estate group in the New York office. I handle all aspects of commercial real estate with a particular focus on leasing, but also handle other types of matters as well. Adria, I'll turn over to Adria to give a short introduction of herself.
Great. Thank you so much, Jason. My name is Adria Crow. I'm a partner in Seyfarth's Chicago office. I'm one of the leaders of the firm's transactional risk practice, as well as I have a mergers and acquisitions employee benefits practice. Jason, I'll turn it to you.
Thank you. So today I'm going to start out by giving an overview of the Corporate Transparency Act, or CTA, including explain what it is, talking about reporting companies, required filings and timing, and explaining the concepts of company applicants and beneficial owners. Adria will then speak about matters relating to compliance with the CTA. So first, what is the CTA? Well, the CTA was passed in 2020. It's called the Corporate Transparency Act. And the stated purpose of the CTA was is to protect the U.S. financial system from illicit use and impending malign actors from abusing legal entities. In effect, the purpose is to seek the disclosure of corporate ownerships and to prevent money laundering. It's administered by the Financial Crimes Enforcement Network, which is a division of the Treasury Department, and that's to whom filings are made. Okay, then who's required to file a report? Well, first, reporting companies. A reporting company is defined is basically, unless it's an entity that includes, it's an entity such as a corporation, limited liability company, a limited partnership, a statutory trust, or what's important to just keep in mind, or any other entity that would be created by the filing of a document with a Secretary of State or similar office, or also with under Indian tribal law or under foreign jurisdictions. There are exemptions which we'll speak about, but a reporting company that does not meet an exemption is required to disclose information regarding their beneficial owners and company applicants. So the three terms to keep in mind when thinking about the CTA is it a reporting is the entity a reporting company? That is not, the first question is it a reporting company? Second question, is it subject to an exemption if it is a reporting company, if it meets the criteria of what would otherwise be a reporting company? And then to think about who are the beneficial owners and company applicants for that entity, if it is. Note that sole proprietorships, general partnerships, and common law trusts which are not created by the filing of a document with the Secretary of State or otherwise, are not covered by the CTA, and no filings would be required. And just to note, FinCEN estimates that there are over 32 million entities that that the reporting requirements would apply to. Next slide, please. So, as I mentioned, there are There are 23 exemptions. So even if an entity is would otherwise meet the criteria by being created by the filing of a document, there are 23 exemptions, types of entities that would not be required to file. Those would include entities that file reports with the SEC. Reason being is that, my understanding, the reason being is that information is publicly available, would otherwise be publicly available through those filings. Governmental authorities, banks, credit unions, money services businesses, investment advisors, brokers and dealers, securities, tax-exempt entities, entities that assist tax-exempt entities, insurance companies, pooled investment vehicles, public utilities, entities that are inactive. Keep that in mind. Inactive entities are exempt. Accounting firms and large operating companies, which we will talk about in a moment. Now, so for those entities that are exempt, most of them, whether it's for convenience or the fact that the information would otherwise be available to the government through other means, so that a filing would not be necessary. That's the idea behind it. Note that if an entity is exempt and then is exempt and then later loses its exemption, that entity would have 30 days to file the required report with FinCEN. Next slide, please. Now, I spoke about large operating companies, which is one of the exemptions. So a large operating company is defined as an entity that, first, employs more than 20 full-time employees in the United States. Two, has an operating presence at a physical office in the United States. So that entity must have a physical office. And three, has filed federal income tax returns or other information for the in the U.S. for the previous year, with evidencing more than $5 million in gross receipts or sales on an IRS Form 1120 or other applicable form, which would exclude receipts or sales from sources outside of the U.S. And all three of those prongs would need to be satisfied in order for an entity, what would otherwise be a reporting company, to be exempt based on a large operating company exemption. Next slide, please. Other exemptions include, as I said, tax-exempt entities, certain subsidiaries of exempt entities. So what that means, FinCEN has provided guidance regarding exempt subsidiaries of tax-exempt entities are based on that exemption. And in order to qualify for an exemption, a subsidiary entity must be both 100% owned and 100% controlled by an exempt entity. So partial control by a tax-exempt entity or partial ownership by a tax-exempt entity would not provide, does not qualify a subsidiary for an exemption. Next slide. Okay. So filings and due dates. Okay, so we'll start with entities that existed. So as I mentioned earlier, the CTA went into effect, became effective January 1, 2024. So with respect to entities that existed before December 31, before just January 1, 2024, those entities have a one-year period to file their beneficial ownership reports, ownership information reports. And those entities are only required to provide information regarding their beneficial ownership, and just not the original company applicants. Which we'll discuss who those are. So it's limited information. All they want to know for the entities that existed as of the end of 2023 is who were the beneficial owners. For entities that have been formed this year, formed prior to January 1, between January 1, 2000, in calendar year 2024, those entities have 90 days to file from and after their date of formation. So, that applies to all entities that have been formed since January 1st of this year. They would have had 90 days to file their reports, and that period will be reduced to 30 days going forward from and after January 1, 2025. Those entities and those entities formed from and after January 1, 2024 will need to disclose both information regarding both beneficial ownership and the beneficial owners and the company applicants. And again, we will discuss those in a bit. A FinCEN has created a website through which these reports are filed. Anybody can go on the FinCEN website and look around and see, and get familiar with it. If information changes, or there was if there was a mistake, any updated or corrected reports must. If there's a change or a mistake, those must be filed within 30 days after the change or the discovery of the inaccurate information. There's a deadline for existing entities that lose their exempt status this year. Okay, next slide, please. So let's talk about company applicants and who they are. Again, we have two categories of two types of individuals, or two categories of individuals, and they might be one and the same. They might, a single individual, may play two roles. It's possible, but a company applicant are those individuals is the individual or individuals who file the document that creates a company, and it's up to two. The individual who filed the document that created the company, and the individual who's primarily responsible for directing or controlling the filing. So what's important to note is there are only up to two company applicants for any filing. There may be one, but it would be the person who's doing the ministerial task of filing filing the report, and the person who manages that person. Now that could be whether that's at a law firm, whether that's done in-house or otherwise. You have to think about who are the two individuals whose information will need to be disclosed. Again, law firms, accounting firms, and other professionals are coming up with their own policies and taking different positions as to when and if they would be willing to serve as a company applicant. So some firms would take the position that they will not they're not going to require their employees or partners, et cetera, to be involved, or they don't want to be involved, and they will give guidance to clients. Other law firms may take a different position and allow it. So it'll vary by firm at this time. There are also, to note, there are third-party service providers a lot of the corporate filers, service providers are developing their own products and providing services to aggregate to file the reports and to gather the information to make the filings, of course, for a fee. Next slide, please. So what company applicants are required to provide the following information on the report: full legal name, date of birth, a current residential address, and a unique identification number, such as an official identification number, such as a driver's license number or a passport number, and provide a copy of the document from which a copy of whether it's a driver's license, passport, or other document from which the ID number came. Next slide, please. Now, just to note, one exception from having to provide that information each time is if an individual obtains a FinCEN ID number. So, which I'll have to say is very convenient. So I've done it myself. It takes about 5 minutes. It took me about 5 minutes to do it. But to obtain a FinCEN ID number, you go through the FinCEN website, you provide your information and a copy of your driver's license, etc. You can do this on your phone, which is how I did it, and you are assigned. A person is then assigned a FinCEN ID number. And then, if going forward on the beneficial ownership information reports, you don't have to provide all that information each time. A person can simply provide their FinCEN ID number. This is especially helpful for those who are going to be, whether it's somebody who's going to be a repeated company applicant, or beneficial owners, where there are a number of entities, where there are numerous entities, where an individual may constitute a substantial, have substantial ownership, whether through management control or ownership control. So that's just something to keep in mind, and for those who have not already obtained one, something to think about doing. Again, it's very easy. My own personal experience. Next slide, please. Okay, so we talked about, the following disclosures are required in the beneficial ownership information report. So with respect to the company, the reporting company as to itself needs to disclose its full legal name, any trade name or doing business as name, a current address in the U.S., its jurisdiction of formation, and its taxpayer identification number, or EIN. Beneficial owners have to provide the same information, full name plus date of birth, U.S. address, as well as what we talked about before. It's like a company applicant, an official ID number, unique identification number from a passport, driver's license, or similar document, plus an image of the document from which the number was taken. Next slide, please. All right, beneficial owners. So the first category we talked about earlier were company applicants. Beneficial owners are individuals that are either, so it's one or the other, and it's direct or indirect. So those beneficial owners are those that directly or indirectly either one, exercise substantial control, including negative control over an entity, such as serving as a senior officer, having the power to appoint or remove senior officers, or make other major decisions on behalf of an entity. FinCEN has issued more detailed guidance as to what constitutes substantial control in the FAQs they've issued and other guidance. The other category is a person, or it could be an individual or an entity. A beneficial owner could be, actually no, it's an individual, I'm sorry, who owns 25% or more of the entity, which may include through means of convertible notes, warrants, options, and other types of instruments, whether or not they have been exercised. So what you're looking at are you're looking up to the top, individuals up to the top of the chain who satisfy either of these two categories. Those individuals would constitute a beneficial owner, would have to be disclosed on a beneficial ownership report, and there is no limit to how many beneficial owners would be required to be disclosed on the number if they meet either of these two categories. Next slide, please. There are penalties, civil and criminal penalties for a willful failure to report, to file a report, or for willfully providing false or fraudulent information on a BOI report, including civil penalties of $500 per day for a continuing violation up to a maximum amount of $10,000, and criminal penalties, potential criminal penalties of up to 2 years in jail. So just to keep that in the back of everyone's mind. But again, this is we haven't yet seen how this is going to be implemented or the enforcement, but these are potential consequences for a willful failure to report or willfully providing false information. Next slide, please. Okay, I'm now going to turn it over to Adria, who's going to speak about compliance with the CTA.
Great. Thanks so much, Jason. So now that you have an understanding of kind of the who, the what, and the when of the CTA, we're now going to discuss kind of in more detail the actions that you should be taking in order to comply with the CTA, as well as some best practices that you can consider. Next slide, please. So, kind of before we get into the whole preparing and the actual filing of your beneficial ownership reports, we kind of want to walk through some of the steps that you should be considering taking today if you haven't already, right? For the entities that need to file by December 31st, 2024, you still have 145 days before you need to make that filing. So you do have some time to kind of get some different processes and procedures in place. So first, and as many of you probably have seen if you've been kind of monitoring the CTA, is you probably want to designate within your organization, a department, an individual who's going to kind of continue to monitor the various guidance that's coming out on the CTA, and then make sure that that person knows exactly within your organization who should be alerted. FinCEN does have, a pretty lengthy FAQ page that we do see updates coming out on those fairly regularly. You can actually go to their website and subscribe to get notifications when updates do come out. So those can be very handy and, come directly into your inbox so that you can understand exactly what has been changed, and they are indicating on those here's the date that this was added, so that you don't have to consistently read the 60 plus pages that are currently out there. And it's important to really stay up to date on the changes and the different clarifications that FinCEN is providing in terms of which entities need to file or who's considered a beneficial owner. They came out with guidance that impacts trusts. Because as Jason talked about, right, if you do need to make any updates to your initial report, you have only 30 days to make those filings. So super important to stay on top of the guidance that's coming out so that you can your teams can get that information as timely as possible. Another kind of consideration, and that we've been hearing employers doing, is actually adopting internal policies regarding CTA. Right, this is information that impacts the company. It's a company specific entity by entity requirement. And so, but yet you're also relying very heavily on information that's going to come from individuals. And so by setting forth a policy, right, that can help your employees, your individuals understand the actual requirements on the company itself, what needs to be provided, and also those responsibilities of please letting us know if there's actual changes, right? Because as Jason mentioned, beneficial owners need to provide current residential addresses. So if an employee moves, right, that information, and if they're a beneficial owner, that information will need to be reported to FinCEN. So laying out kind of those policies and having them available to employees to refer to can be super helpful in ensuring kind of ongoing compliance with your reporting requirements. Also, again, as this is a new aspect, a new reporting requirement, doing CTA related training might be important. Again, you've maybe designated the one person who's going to continue to monitor updates and additional guidance that come out. But then there's also the question of, well, who's going to be responsible for collecting the information? Who's going to be responsible for actually preparing and filing, and then saving any of the information that you do actually file with FinCEN. So establishing those procedures, that workflow, that data flow, can also be super helpful in making sure that, when it gets towards that deadline, December 31st, for those entities that have been in place prior to January 1 of this year, then you kind of know exactly who to go to, who should be collecting that information, and that the full team kind of understands the different deadlines that are going to apply to that. I think, another important aspect of this is, depending on who you designate within your organization to be responsible for the preparation and filing, there could be changes within the organization that they're just not aware of. For example, if there's some sort of corporate restructuring or an M&A transaction that's not fully publicized within the company, those are the types of things that could definitely impact whether an exemption applies or if there's another entity that might need to file. So making sure kind of the various stakeholders within your organization understand, again, what the Corporate Transparency Act requires and of whom will be helpful so that you can, again, mitigate those risks of having untimely or inaccurate filings. I think, and then again, we want to stress that each company is potentially a reporting company unless an exemption otherwise applies. So for some of the larger organizations, or if you have multiple subsidiaries where you may have certain back office functions held at a parent level or by another organization, it may be helpful for you once you're setting up this training, doing these policies, these procedures, to make sure that everyone knows who to go to, or that the subsidiary doesn't make a filing that's maybe inconsistent with how other subsidiaries are filing or making their exemptions. Obviously there could be instances in which one subsidiary has an exemption and another does not, but it's just something to keep in mind when you have large organizations, of trying to make sure that everyone is kind of taking consistent approaches and understanding how these requirements apply to them. As part of that, right, with your organization, whether you're small, whether you're large, right, this is a really great opportunity to, before the deadline, is to take a look at your corporate governance documents, right? Making sure you have up-to-date org charts. Is your cap table up to date? Have you reflected all of the different, equity awards and grants that you've recently done? And making sure all your other kind of records are up to date, right? doing that, that'll just help with some of the legwork and identifying, okay, here's the different entities within our structure. Are they going to potentially be implicated by these requirements? Do we actually have a sense of who might be these beneficial owners or these control people who we're going to need to have their information so that we can make our reporting, at the end of December. And so once you kind of have those nice policies, procedures in place, right, then the next step is actually deciding, who are we actually a reporting company, right? And do any of those exemptions that Jason talked about, are any of those going to actually be applicable to us? While there is a lot of good guidance out there, some of the situations just aren't as clear cut as you would like them to be. So it may take some time to kind of dig into some of the what industries you're in or the trusts that exist to identify, are we exempt? Are we not exempt? Do we meet the large operating company exemption? How do I determine who a full-time employee is for that purpose? So giving yourself some time to evaluate those exemptions. And then also we'd really recommend that, once you do decide if an exemption applies or not, but particularly if you do believe that one does and you don't need to make a report, is to actually document that. Put that, get a kind of a memo, file memo, internal memorandum, kind of outlining your analysis as to why that exemption applies. Because as Jason noted, right, there are civil and potentially criminal penalties that do apply if you willfully decide, don't comply with the CTA. So by having that memorandum of, here's what we did, this is what we looked at, I think, that's definitely some evidence, some documentation that reflects that there wasn't an intent to not to file. Next slide, please. Great. So now, once you've figured out if you are a reporting company and whether an exemption applies, now it's kind of that time piece to start actually collecting all the information that's going to be required to be included in your filing, right? So collecting the information on the reporting company itself, again, depending on who you've designated within the company to do that, maybe they'll need to go to legal, maybe they'll need to go to your chief legal officer to kind of get that information. Then also, right, it's that identification of all of those beneficial owners and control persons. And as Jason noted, there is no limit on how many people that could be. And so this could be a pretty time-intensive activity to go out to all of those people. They may need to go, if it's a trust, right, they might need to go to someone else to get some of that information. And so giving yourself enough lead time to do that and not waiting till, December 25th to start remembering, oh, we've got 6 days, 7 days to file this, is definitely something that you should kind of keep in mind. So collecting all of that information, again, and giving people too, if they want the opportunity to get the FinCEN identification number, although Jason said it's a pretty quick process, right? You still want to give people that time to go and get those numbers, and then provide that back to you so that you can include that in the report itself. So, right, you need to get that information for the beneficial owners, for people who are considered control persons, and then as well for those companies who started in their existence from January 1st, 2024 and onward, you will also need to identify those company applicants and provide the information that Jason noted before. Okay. And then, I think one thing, remember again, as we noted, the IDs, they're not mandatory. But they can help to minimize some of the information that company personnel may need to handle, right, in the days of data privacy and data security. So having some of the less information and just having that FinCEN ID would help to mitigate some of those risks. But it is important, and probably as part of your communications to people who are beneficial owners, if they do get FinCEN IDs, it is super important to remind them that if there are changes, again, to names, addresses, even, if you do your passport renewals or you get a new state ID, that information is going to need to be submitted to FinCEN to that, to update your application. So just reminding employees if they're going to use those FinCEN IDs, that will be their responsibility to update those. I think the only other thing, and some of the questions we get is about, maybe I set up my FinCEN ID and then I want it. For now, there is not a specific way you can deactivate.
Looks like we lost Adria. Her connection probably dropped.
Okay, well, while we wait for her, I can, I can just add just a few points, because in addition to, other things to do, or to think about, on the company side in terms of, Adria was talking about employees. Oh, Adria, you're back? I'm going to turn it back to you, and then I'll.
Okay, perfect. Thank you. Sorry about that. So kind of the next, Joanna, can we go to the next slide? Perfect. Thank you. All right, great. So now that you have collected all of that information, right, as Jason talked about, there are some very strict deadlines. And so you want to keep those deadlines in mind, particularly if you're going to use a third party. You want to make sure that you confirm with them the deadline of when you would need to submit all of that information so that they can also timely submit those reports on your behalf. So again, if you are a non-exempt reporting company and you existed prior to January 1st, 2024, you do need to do your initial report by December 31st, 2024. So, it might be a good practice, right, to put a reminder in your Outlook right now and put a couple of reminders a few weeks out, just to make sure that you don't miss that deadline. And then again, for those reporting companies that were established on January 1, 2024 and after, you had 90 days to do your initial filing. And then for any entities that are established January 1, 2025 and after, you have 30 days to do your initial report. And then, right, once you have kind of all of that information, as Jason noted before, you would prepare and make the filing on FinCEN's portal. Once you do your submission, what you should be receiving is an acknowledgement as to whether your submission was received successfully or if there was a failure in the transmission. And then you should also be able to download a transcript of your actual report. If you're using a third party, then that kind of specific information would not be available and you would need to request that directly from that third party. We do highly recommend that you retain those confirmations and those transcripts for your own records, right? To demonstrate that you've actually complied, but you also may need to reference them when you have subsequent filings. Joanna, can you do the next slide, please? Great. And so once you've made that initial filing, like I said, right, and as Jason mentioned, you should also kind of continue to monitor compliance and identify whether you need to make any updates to your initial report, or if there were any kind of potential inaccuracies in any of the reports. It can be a bit difficult because these aren't annual requirements like your SEC Form 10Ks or your IRS Forms 5500, where each year you're going to have to file, you're going to have to put these together. And it's really just every time there's a potential update, you might need to submit an updated BOIR to FinCEN. So this is why kind of keeping track of the copies of your prior report transcripts would be super helpful, because to the extent you do need to make updates, unfortunately, it's not just saying, hey, my entity name changed, or I'm a beneficial owner and I moved. What you're doing is you are submitting a complete report again. So it's going to reflect not only the updated information, but all of the other information that hadn't changed. So again, keeping those transcripts can be a good way to kind of pull that information forward, so you're not having to go back and try to figure out what you may have done, 6 months, 2 years prior. And then here, kind of what we've noted are some different kind of examples of when you actually might need to make changes to your initial reports, right? So if there are changes to the actual reporting company itself, changes in beneficial owners and control people, right? Those generally need to be reported within 30 days. If you've identified any inaccuracies in any of your reports, again, you have 30 days of discovery to make those new reports. As well as, maybe there's some changes to whether an exemption does or does not apply. With respect to the exemptions, right? Potentially, if you're relying on that large operating company and then all of a sudden you're under that 20 full-time employee count, you might need to then report to FinCEN about the loss of that exemption. I think notably for people in 2024, if you had an exemption and you lost it during 2024, then to file your report, you get the latter of basically December 31st or 30 days from when that exemption loss occurred. So for example, if you lost your exemption on December 15th of this year, you would have up to 30 days from December 15th to do that filing. You wouldn't need to squeeze it in those last kind of 16 days of the year. And then, one thing to keep in mind, and that not reflected here, purposefully, is if there are changes to company applicants, and remember, company applicants only need to be filed for those entities that were in existence on or after January 1 of 2024. You do not need to make any filing updates if there's changes to those company applicants, unless that person is also considered a beneficial owner or a control person. So changes to your company applicants, if they don't fit into another kind of reporting requirement, do not need to be updated to FinCEN. And then finally on this, if you do become exempt, if you're currently a reporting company and then you do later become exempt, you do need to update your report to FinCEN within those 30 days. In that case, you only need to identify kind of the entity itself, and then there's a box on there that you check that says the entity is newly exempt. So that's the one case where you don't have to refile all of that information about the beneficial owners. Next slide. Great. And so then, just some other kind of best practices for you to consider as you're exploring and putting into place the different policies and procedures is, obviously data security. You are getting, some sensitive information from employees if they're not getting FinCENs, right? It could have their passport, it could have their driver's license. And so evaluating and how you're going to create secure processes for collecting and storing that information is really important, right? Depending on how your organization is structured and who you decide is going to be responsible for managing and collecting that information, you might need to revise some internal processes or procedures, put different safeguards in place to make sure that that data is not, being compromised, or how you want to securely transmit that information to third parties if you're going to use a third party to help you with those filings. Also, obviously, as Jason mentioned, foreign entities, non-US entities might be subject to having to make these filings. And so it's also important to evaluate with counsel and any kind of particular privacy law concerns that may apply to those individuals outside of the United States for purposes of making the filings, and again, sharing any types of information with third parties who might be assisting with that process. And then kind of just some more general company practices, right? Again, as we talked about, it's a good time to kind of scrub and go through some of your corporate organization and governance documents, looking at shareholders agreements, investment questionnaires when you're putting together grant awards for options. So again, you might need information from those people who are getting those documents, who are the counterparties. And so whether it makes sense to include provisions in there to address and state, affirmative covenants that they're going to provide you the information that you'll require in order to complete your forms. There are penalties that can be assessed on the individuals themselves if they cause the company to fail to report in general, or to have accurate information. So, this is important on the individual level as well. But again, considering if your company kind of wants to add kind of additional language in your employment agreements, in those equity awards, just so that, again, you kind of have some additional contractual safeguards in place to make sure that you can get the information that you'll require. The other piece here is, on inactive entities. Again, as we talked about, each entity, unless otherwise exempt, they'll need to make a filing. So unless an entity has been kind of formally and irrevocably dissolved, a filing would be required. So it might be a good time to kind of, again, look through your structure chart and see if there's some entities that might not be operational and that you've been putting off dissolving. It might be a good time to consider that again before you need to continue to do filings for those entities. Next slide. Okay. And as Joanna mentioned at the start of the program, we do intend for this program to qualify for CLE credit. If you would like to request that credit, please scan the QR code on the screen. And then the attendance verification code is SS8542. That's SS as in Seyfarth Shaw, 8542. Next slide. Okay. So we do have a few questions in the chat here that we will take a couple minutes to address. I know we're running up a little bit on time here. So we'll just address as many as we can while we have some time. Jason, one of the questions that we received is, what types of provisions should we expect to see in purchase and sale agreements, real estate leases, loan documents, other transaction docs?
Sure. So in my view, purchase and sale agreements and leases, I don't typically see it, and I don't really think it. In my view, it's not really pertinent as a general matter to have to address the CTA compliance when it comes to a purchase agreement or a lease. As a general, in terms of loan documents, I have seen provisions requiring compliance with CTA. As a general matter, borrowers will be required to comply with law. That's a compliance with law matter. And then when it comes to, I would see, and Adria, you touched upon it, when it comes to joint venture agreements, I would say, in my view, that's kind of something really to keep it in mind, because when it comes to a joint venture agreement, remember the reporting company is the entity itself, so that to make sure that the joint venture, that whether it's the managing member of a joint venture or a partnership or general partner, that to provide that those persons who satisfy the definition of a beneficial owner through ownership or control will be required to provide that information. To provide the initial information, and also be required to provide any updates of that information from time to time. And ultimately, it's going to be who's going to manage the process, and whether there's in terms of because look, it's kind of an allocation of risk too. Who bears the burden of updating their information, and will people forget to do it? No doubt, people are going to. It's not you're moving, you change jobs. Is the first thing you're thinking about is to update beneficial ownership information. Now that you also talked about employment agreements. It may be something for companies to think about in terms of onboarding and offboarding, to address or remind individuals that they need to update their beneficial ownership or their beneficial ownership information on reports or even et cetera. So hopefully that answers the question.
Yeah, I agree. And I do think even from an M&A perspective, we have not yet seen specific representations or warranties in their kind of addressing CTA. But, normally there are those broad general compliance with law provisions like you mentioned. Now, I do think as we get closer to December 31st, and a lot of entities might need to start doing their initial filing, and if depending on your interim period, it is something for buyers to consider whether you want to include an interim covenant, saying you're going to file, or if you do file, right, that maybe we get some sort of review and approval rights of the information, or that we agree with that I correctly identified that an exemption applies, right? Because there are still those penalties that can apply. So it's something I think yet to be seen, but I haven't seen that yet in the purchase and sale agreements that I've come across.
Now, I do see that in the corporate context, there may be more sensitivity there than in my world of real estate, where it's not necessarily as critical. Now, I saw there were a few questions about, and I'll try to hit all, aggregate about large operating companies and the exemption, and to restate what the requirements are, and also, can a single member LLC qualify? So just to go over again what the three prongs that have to be satisfied. That it would be an entity, what would otherwise be a reporting company that employs more than 20 full-time employees in the United States. Second, has an operating presence at a physical office in the United States. And third, has filed federal income tax or an information return in the United States for the previous year that demonstrates more than $5 million in gross receipts or sales on that entity's, not other subsidiaries or anything, on that entity's IRS form 1120 or other form, excluding gross receipts and sales from sources outside the U.S. So what you're looking at is each entity is treated individually, as far as I understand, that each entity is looking at, does the entity itself qualify as a reporting company? It doesn't matter whether the individual is a single member LLC, multiple member LLC. It's just, does the entity that is created by an entity that's created by the filing of a document, does it satisfy those three tests? The answer is yes. It meets the large operating company exemption at that moment in time, unless it later doesn't. So that's in terms of. And again, you're looking at the entity itself. There's not a consolidated report that includes subsidiaries. If you have, if there's an umbrella company that's a reporting company that satisfies the requirements, it has to report. If you look at if it has subsidiaries, you're looking at each subsidiary individually, as far as I understand. I might, except if it's especially if it's a partially owned subsidiary, you have to do an analysis for each entity. Does it satisfy it, including does it meet the exemption for being owned by an exempt entity? So you're doing an analysis of each entity on a one-by-one basis.
Yes, and I agree. And from an employee perspective, right? Sometimes you may have certain employees at one entity. And so say you have 5 employees at one entity and 15 at another, and they may be considered a single employer for benefit plan purposes. But it's important for purposes of that large operating company exemption, you would not be able to aggregate those 2 entities together to get your 20. So it is important, again, to kind of understand where those employees sit for each of those entities. I also did see that there was a question in the chat about S corporations. S corporations do, unless there is an exemption that applies, an S corporation would need to potentially file under the Corporate Transparency Act.
Let's see.
Okay. Well, I know that we are running out of time here and we don't have enough time to get to all of the questions here. These are some really great questions. We'll definitely, be able to reach out to people and try to address as many of these as possible. So we thank you so much for joining us today. We hope that you found this presentation helpful. Thank you.